Now, first, just bear with me. I'm not going to overdo these clips of Obama because most of you don't want to put a gun in your mouth. But I want you to listen to this part of his speech last night. It's only 30 seconds.
With all due deference to separation of powers, last week the Supreme Court reversed a century of law that I believe will open the floodgates for special interests, including foreign corporations, to spend without limit in our elections. I don't think American elections should be bankrolled by America's most powerful interests, or worse, by foreign entities. They should be decided by the American people. And I'd urge Democrats and Republicans to pass a bill that helps correct some of these problems.
During the course of that, Alito mouthed, "That's not true." Now, here's the problem. Past presidents have criticized the Supreme Court during State of the Union speeches, saying that they've disagreed with this or that. But that's not the issue here. The issue here is an outright fabrication by the President of the United States looking down on six of the Supreme Court justices, lying to them, lying about them, and smearing them at a State of the Union address. And I seriously doubt most of the justices will go back to the State of the Union address because they are guests. They're not required to be there, given how this president tried to use them for political purposes. So no, it's not an attack on the independence of the court. One branch can talk about another. They do all the time in their own way, with their own role. I don't have a problem with that. It's what he said, the substance, and the way he said it. That's the problem. And I have to say that Obama is incredibly stupid or incredibly devious. I don't know which is worse. Now, here's the truth. And I cite Bradley Smith, who used to be on the Federal Election Commission, is one of the greatest minds on this issue of free speech and campaign laws. And he's a professor of law at Capital University Law School now. Here's what he says on National View Online on the corner. He says, the full story is this. Please listen. This is crucial so you can understand how diabolical or moronic Obama and Biden are, how vicious they are, how moronic or diabolical the media in this country are for not getting this straight. But now you'll have the straight facts, and we will also link to this on marklevinshow.com. Bradley Smith writes, the Citizens United case dealt with a blanket ban on corporate expenditures. The court struck down the ban, which is Part 2, United States Code 441B. A separate section of the law, 2 U.S.C. 441E, prohibits, quote, foreign nationals, unquote, from making expenditures or contributions. Now, foreign nationals includes corporations that are not incorporated or headquartered in the United States. This is an extremely broad prohibition that applies to any United States election, including state and local elections, and to any activity, quote, in connection with, unquote, any election. The Citizens United ruling doesn't touch this prohibition and specifically notes that it makes no judgment about foreign corporations. This would allow U.S. corporations, incorporated and headquartered in the United States, to make expenditures. Remember, Obama referred to foreign corporations. But Federal Election Commission regulations, 11 CFR 110.20, further delineate the prohibition. It says, quote, a foreign national shall not direct, dictate, control, or directly or indirectly participate in the decision-making process of any person, such as a corporation, labor organization, political committee, or political organization, with regard to such person's federal or non-federal election-related activities, such as decisions concerning the making of contributions, donations, expenditures, or disbursements in connection with elections for any federal, state, or local office, or decisions concerning the administration of a political committee. I don't know how you could write it more broadly than that. This remains federal law. This is an FEC regulation. And the court didn't touch it. Furthermore, the FEC requires that any funds so spent come from U.S.-generated income. In other words, the parent corporation cannot send capital to the United States subsidiary and then have the subsidiary spend that in connection with U.S. elections. Therefore, you could have a foreign-owned but U.S. incorporated and headquartered subsidiary using U.S. funds controlled solely by U.S. nationals make expenditures. However, bear in mind, such a corporation is already able to operate a political action committee, which can make unlimited expenditures and also contribute directly to candidates and spend unlimited sums from any source, and its executives and managers who are U.S. citizens, are lawful permanent residents, are already eligible to spend unlimited sums on U.S. elections. So, bottom line, claiming that the Citizens United decision will allow, quote, foreign corporations to spend without limits in our elections, unquote, is as misleading as saying that Obama and the Democratic Congress have allowed foreign corporations to already spend without limits in our elections. The corporate ban is not about foreign contributions, and the government never tried to defend it as such. To suggest that this ruling allows foreign expenditures in elections is wholly misleading. All the court did was say this aspect of the McCain-Feingold bill, which outlaws advocacy ads by corporations, profit-making or nonprofit, or for that matter, anybody else, 30 days before a primary or 60 days before a general, is unconstitutional. It didn't expand the power of corporations to directly affect elections through contributions to candidates. It didn't change it at all. It didn't change it at all. All that it allows now is for them to run ads on TV, essentially. That was the battle. Ads on TV prior to an election telling you what they like or don't like about a particular candidate. That's it. And if there's any foreign money involved, it's very unlikely that any of it can be used or will be used to fund those advertisements. Because all the prohibitions on the use of foreign money remain in place. They weren't touched by the court. So to say that the Supreme Court changed 100 years of precedent is a bald-faced lie. They changed McCain-Feingold because it was unconstitutional, which is not 100 years old. It is very, very important that you understand why Samuel Alito's sitting there and knowing all of this when he heard Obama say what he said, mouthed, that is not true, or that's not true, because it wasn't true. And yet we have one of the anti-free speech morons, Russ Feingold of Wisconsin, according to Politico, sharply criticizing Sam Alito's reaction to Obama's State of the Union, calling the justice's behavior inappropriate. That's not very judicial of him, Feingold told Politico. Apparently he thinks he gets to make the law. He should maintain his judicial demeanor, and that was inappropriate. No, Feingold, what's inappropriate is you trying to destroy the First Amendment and your hero, Obama, lying about what the Supreme Court did. And let me tell you what's going on here, ladies and gentlemen. They're trying to intimidate those 5 justices. They're trying to intimidate them, so the issue of campaign laws and free speech, if it ever comes before the court again, and it will, those justices will theoretically be concerned about how the President and Congress responds to them, as opposed to interpreting the Constitution and applying it to the law. That is the statute. That's why what Obama did is so diabolical and menacing, because he was trying to influence future decisions of this court by lying to the American people in the biggest speech he's given yet about what the court did and about what the facts are.